Hello everyone, good evening. So my presentation brings us to the fag end of technical sessions. So I've tried to be a bit interesting and fun, that only you can tell in the end. So may I have a show of hands, how many people are from law firm industry? Okay, and from in-house counsels, any? Okay, so a part of my presentation also focuses on client management. Whenever we deal with freedom to operate, so this basically is about my experiences and also how to deal with client management. Unilever is basically a fast FMCG company, fast-moving consumer company. Goods company, and we always have a joke among ourselves that either something is urgent or it's very urgent, and the answer is that because it is fast moving consumer goods, so everything is moving very fast because we have to react to consumer insights, we have to be very responsive, and we have to be very responsive to what happens in the competitor market. So everything has to be developed very fast, launched very fast, and therefore a lot of freedom to operate opinions are required for these launches. So I'm sure everyone knows this, but what is freedom to operate? The ability to perform a particular commercial activity without infringing third parties' valid IP rights. So many people relate FTO to only product launches, but whereas it could be different processes involved in the industry. So we need to make our clients be aware that even if you change the process of a particular, making a particular product, you need to get a freedom to operate opinion. So what is in a name? So we call FTO by different names like clearances, freedom to operate, risk analysis, and other names. Do you think any of those mean differently? Anyone with some comments on that? Do they mean differently or do they mean the same? Same? Okay, let's see. So Shakespeare says, what's in a name? That which we call rose by any other name would smell as sweet. So that's what Shakespeare says. Let's see what names we call freedom to operate by. So freedom to operate, white space scouting, clearance, and risk analysis. So what difference does it make when we call it by different names? So it's all about expectations. So freedom to operate would give a feeling like I'm free to operate or launch this. White space scouting would give a feeling that this is a white space to launch. Wow, I got this space. Clearance would mean, yay, I got the clearance. And risk analysis would mean need to understand the risk. So as per my experience, it's I would personally find better to call it as risk analysis without raising the expectations of the clients receiving the opinion, because clearance is a very wow word. So when you say you got the clearance, it's like, yeah, go ahead. So there are no risks involved, whereas it's never the case. As we all know in the patent profession, it's never the case that there is no risk. There's always some risk. So business needs and expectations. So basically being an in-house counsel, it's the business which is the internal client or customer for us. And what are the business needs and expectations? It's when they're launching a new product. So this is the business need, and what are the expectations behind it? Clearance is needed ASAP. So nearing a contract gate, they're going to get a contract, spend money. And what's the expectation? Clearance is needed before the contract gate. So everything you see is so much pressure, so much of urgency. Then big financial and or resource investment. So clearance is again needed ASAP for business decision on investment. Then the external opportunities. So again, clearance is needed ASAP. We need to acquire a company, in-license the technology. So that's the expectation. So have you ever felt like this, like you would want to stop the clock? Or have you ever heard the words, I want what I want and I want it now? So these are the words we get to hear, and we have to then explain that it's not quite possible to give an FTA opinion like that. So what does a typical freedom to operate exercise involves? It involves an attorney is provided with details of commercial activity along with the geographical indication for the activity. Here geographical indication should not be confused as the geographical indication we use. It means the place for launch of that product, or the place of manufacture of the process for which the clearance is sought. So all the details are needed to be given, because if some details are missing, then it gets very difficult. Then attorney analyzes the information to identify key features for searching. Sometimes we have to go to and fro to ask for more information. Then details of commercial activity provided to the search analysis with a brief from attorney. Attorney tells that what are the most important key features which a searcher should keep in mind before searching. Then a search is conducted by search analyst, and report is provided to the attorney. Then the attorney analyzes the search results and assesses the risk, and an additional invalidity search may be needed if there is any patent document which is blocking the technology. Then communication of the opinion to the team and management such that they are able to appreciate the risk. So this is very important, that the business understands what the risks are. So what are typical attorney challenges? Getting the correct information, dealing with the unknown. So it's very important, like many a times we are not given the complete information, and then sometimes information keeps pouring in at later stages and it gets difficult. So it's like being scared of the unknown. Then quite often information rests with third-party vendors who are hesitant to share the details. So it's quite possible while making a product, some particular small bit of it is bought from a third-party vendor, and they're not very ready to share the details, so it poses a problem there. Then analyzing pending application, we see, and all of us would have experienced of seeing very broadly written applications, and don't really know how they would turn out to be, and especially in US jurisdiction when there could be many continuation in parts and all kind of things could be filed. So at the beginning you can't really understand what shape it would take few years down the line. Then forming an opinion on granted apparent broad claims. So many a times when you would discuss claims with the R&D or business, they would say, oh, this is very broad, everyone is doing this, how can they patent it? But then you have to tell them that this is what it is in force, and we just can't say that everyone is doing it, and so it is not a risk. So it is very difficult to convince the customer or the client at that point in time that yes, this is granted and you have to believe this. Then Chinese utility models, again, very easy to get granted, and then there are so many of them that they block the way. Like most of the time something is blocking. So how to deal with them is another challenge. Then deep diving into documents, file wrapper, prosecution history, cited prior arts and various office actions of different jurisdictions. So when you end up with either granted apparent broad claims or pending applications, and you see that they are still blocking the product launch or the process for which clearance is sought, then you go and deep dive into the documents file wrapper, which is like a huge amount of work, and especially when there are more than one of such documents that you have to deal with. Then other language documents. So Chinese is big on that. So there's so many Chinese documents which you will not find any other language document. You will not find a PCT document. So it's just a Chinese written document. I mean, when you go to any database for that, then there is some translation which just does, machine translation which just doesn't make sense. So you have to get a human translation done for that, and that takes few days. Then dealing with jurisdictions with little or no electronically available filing information. So what do you do if someone has to file a patent in like Turkey? Turkey is still better, but many other countries like Afghanistan, I would say don't care, but sometimes we get requests like that. Then buying time for additional invalidity searches. Now everyone has worked very hard to provide the results as ASAP. Like searcher has done his best to do a search in like 48 hours. I have done my best to analyze the documents in 48 hours, but then we have so many documents which block our way. So then another invalidity search has to be done. So that's another time consuming and process. Changes in initially defined commercial activity. This is the worst. So the first business says that this is the product, and then they come out with, no, this is now we have changed this, now it's like that. So I get a feeling, not again, please. Communicating the dreaded news. So if there is a document which is blocking the way, and you really can't find any invalidating document, then it's a bad news for business. They don't want to hear it, but then you have to communicate this.